Good evening. Can you hear me at the back? Can you hear me at the back? Okay. Geoffrey Nice is my name. The Social Context of Law series was established in order to ensure that contemporary and sometimes controversial issues can be discussed, sometimes in a combative way, sometimes not, between leading experts of this country, possibly of the world, often lawyers themselves, but not always, on issues of concern. And this evening we are very fortunate in the panel we have, who will be introduced by our chair, Estelle Dehon, KC. You will have looked people up on the internet to find out who they are. Let me focus on the fact that she is environmental law focused in a way that will be of great importance, I'm sure, for cases to come, and with luck for the benefit of the world as a whole. She'll introduce the other two speakers. This is a subject about which I know more or less nothing, so I'm going to learn a great deal this evening. And I just thought I'd indulge myself with 30 seconds of information about a different form of funding. 5 decades ago, when I started out, the bar was just moving from an age when, after the Second World War, 2, 3, 4 new barristers started every year, not many more. I think that's about right. To the time when hundreds joined and the bar doubled in size. Why did that happen? Because the form of funding available was legal aid. And it became ever more generous, too generous, it had to be changed. But it, for the meanwhile, allowed people who might not otherwise have got to the bar to get to the bar and practice in both criminal, civil, family, as divorce it was probably called then. And then it all changed with conditional fees. Nothing to do with tonight's realities, but nevertheless interesting that funding can be that important, that it actually shaped the bar all those decades ago. It really did. A couple of things about the way we run these events. I'm afraid I'm allowed to be bossy and then nobody else has to be. When it comes to questions and answers, please have your question prepared in your head or on paper, sub-edited down to 30 seconds. And if you go over 30 seconds, we'll shut you off. Everything can be said in 30 seconds if you try. No need to thank the speakers, that's patronizing. No need to identify yourself. We just want your question or comment in 30 seconds. And that means what? We get the maximum benefit out of our speakers, and we learn more than we otherwise would. After the event is closed here, there's a reception outside. And as opposed to joining together, our eminent speakers will each be chained as if a Bible to a table with their name on it. And the first person to get there can go and get them a drink from the bar. And they will then be available to speak to as many students and members of the public and other who may wish to speak to them. But please remember, 30 seconds for your question and comment, and we really make very great progress. I must thank the library who will have put together a document containing further reading for you, but we must thank them all for that, as well as for those who organised the event. And Estelle Dehon, it's over to you.
Thank you very much, Sir Geoffrey. That was a wonderful introduction, and I'm very pleased to be tasked this evening with a pleasant set of duties. In a second, I'll turn to the first of those, which is to introduce our eminent panel. But first, let me run through just how this evening is going to work. So each of our speakers will talk for an initial 10 minutes. And then we'll have a moderated discussion between us around the topic. for maybe 15 to 20 minutes, and then it will be over to you for your 30-second questions, and or for those of you who are joining us online, thank you very much indeed and welcome, your questions in the Q&A function. I will be toggling between IRL and online, and we'll see where we get to with getting through all of this evening's questions. So we couldn't have asked really for two better informed speakers to talk this evening about mass litigation and the legal system in this country and any implications for the UK economy. First, we have Fredrik Erixon, who is a distinguished Swedish economist, co-founder of the Brussels-based think tank, the European Centre for International Political Economy. He's authored a number of papers on the rise of mass litigation in Europe, but you might be interested to know that in a previous career, he worked, well, it says on the website, developing policy and with government. But that actually means that he advised two different heads of government in two different countries, and indeed worked with the World Bank based in Nairobi. I note that he comes this evening armed with a copy of Isaiah Berlin, having once been the recipient of a scholarship named for that philosopher. We then have Martyn, who's senior partner of Leigh and co-founder of the firm, and he specialises in international environment and product liability claims, often brought as group actions. He really needs no introduction to a legal group, having been the head of a team of over 20 lawyers for a long time, representing claimants in very high-profile, long-running, controversial cases, both in this country and abroad. Always with a reputation for fighting for the underdog. Martyn, will you start us off, please?
Great. Is it on to
Yes, of course.
Right. Welcome. Thank you very much indeed for coming, and thanks to Estelle and to Geoffrey for their kind words. The title of this, in terms of law in its context, is reminded me that when I first went to Warwick University, the law course there was called Law in Social Context. And a few years ago, they very kindly gave me an honorary PhD, saying that I epitomised what they were trying to achieve in terms of that. Now, it'd be nice to tell you that I had some sort of life planned out from the early days, that I was going to have this sort of scene of going into life in social context, and going to university was all because of that. But actually, the main reason I went to Warwick University was my girlfriend was going there. So it was one of those sort of shifts of life that kind of found me in the right direction. The firm got going in 1987, and shortly after, a few years later, we managed to get legal aid for a big group case that took into Toby Hooper here earlier. He reminded me that he was on the panel that awarded us the legal aid for that case. And it was huge at the time to get legal aid for a group claim. And it was a massive case to do with childhood leukemia around the Sellafield nuclear plant. And unfortunately we didn't win, but the trial lasted for a year. It was massively interesting, and I realised it really where my life was going to be, and so it has proved. Since, as a result of doing that sort of case, Lord Rolfe back in the 1990s, when he was looking at his whole changes to the civil justice system, very kindly asked me to be on his committee, and was part, therefore, of setting up the group litigation order system. Now, that, for those of you not involved, is the kind of the main way of actually bringing a group claim within the High Court, the King's Bench division these days. And that process that Lord Wolfe came up with around 99 or so. Since that time, I was just looking this morning to kind of check out for the history in terms of the position of numbers of group claims that have been brought under that system. There have been 125 over the last 25 years. So that is an average of 5 per year. Now, I should tell you that in the United States, they have over 1,000 class actions every year. That, in comparison, we are miles and miles and miles behind. But what's interesting is that in the early days when the system first got into place, legal aid was pretty much withdrawn in the early to mid 2000s. So by the time you got into the late 2000s, there were almost no legal aid cases that you could bring under the group claim system. And it meant that we really fell in the doldrums, because the only cases you could bring were relatively small beer cases, maybe worth a handful of millions of pounds, where the legal cost might be £500,000, that sort of thing. But it just meant that there were hardly any big cases being brought. That carried on really until we got to about 7 years ago, give or take, when suddenly we've started to find these funders who have started to bring money into the system. Now, these are funding outfits that originally started by bringing, helping to fund individual actions in relation to the commercial sector. And they did pretty well out of it. And as a result of which, they thought that it would be good to diversify into mass claims. And the difficulty is, or the issue it became, and I think is kind of a significant point for the discussion today, is that for a funding case to work, you have to have a claim that's worth around £100 million. Now, the reason for that is that in most cases, the way they make their money is that if they do the deal with the claimants, that they get around 30%. That would be an average, minimum 25%, maximum can be as much as 50%, but it mostly hovers around 30-35%. So if you've got a claim of 100 million, then they can assume that they will rake in about 30 million. They look for a return of 3 times their investment. So you can then see in most cases, in the large cases that you need to bring if they're worth 100 million, the cost will be around 10 to 15 million, give or take. So you just have to do the maths to see that suddenly we move from this world where the number of cases were relatively small, but those that there were handfuls of millions. If you had a case that was worth 20 to 30 million, that would really be pretty large. But as I say, that's changed dramatically since the input of the funders. Because if you've got a claim that's, say, worth 30 million, they just won't touch it, wouldn't even get out of bed to kind of even look at it. So the funding world has meant that two or three things. The first is there are hardly any new human rights-y, more lefty firms out there to represent ordinary individuals in group claims that were formed after about 1990. I'm not saying none, but they're very, very few. And since the new funders have come into operation 6-7 years ago, we've seen a plethora. On the emission cases, which I'm much involved in at the moment, there are 22 claimant law firms who are involved in that case. Well, that, compared to what's historically been going on in the group action world, is enormous. And obviously the good thing is that it means that there's much more choice for consumers to be able to bring claims. There are more lawyers involved. It's encouraged more people to get into that field than was ever true before. The other side of what's been going on is the CAT, the Competition Appeal Tribunal, where opt-out, do you all understand opt-out? Well, very quickly, group claims are opt-in. You have to sign up individual clients, you have to fill out their details on the claim form. They are known people. And so there's a big job in terms of bringing all those cases in, people who want to bring a claim. So in terms of the emission cases, every single person who's got a car and wants to bring a claim, their name is on one of the claim forms. With opt-out, it means that it's like a class action in the United States. So you get somebody who leads the class, but they represent the class as a whole. So there's a famous case called Walter Merrick's, who took on MasterCard to do with the interest rates on MasterCard. And that was basically on behalf of all MasterCard users from a particular period. So 99.9% of people would never know that they were actually a part of this group who were bringing the action. Now, the advantage for that for the funders is that these claims can be worth hundreds of millions and even billions. So it suddenly means that that if they lend you 10, 15, 20 million, they can see that they will get the sort of return. So that has encouraged far more cases within the Competition Appeal Tribunal. So that regime started 10 years ago, give or take. And the first 2 or 3 years, nothing happened. But in the last 5 or 6 years, there have been something like 50 cases that have started in the CAT. And largely driven by funding. Now, one of the issues of the CAT is that it's very front-loaded. To become a certified case, i.e. certified to be a class, the court has got to approve it. And to approve it, you've got to show you've got a good case, you've got good experts, you've got decent evidence, you've got a good system in place. That is very front-loaded. And often you will see that the costs of getting to that stage may be £3, £4, £5 million. So there are very few firms who could afford to do that without funding behind them. And the cost may in the end be as much as £20 million and even more. So in that MasterCard case I was just mentioning to you, Walter Merrick's brought this case, thought it was worth a few billion. Things didn't go brilliantly in court. They ended up doing a deal for 200 million. It became apparent that the costs that the funder had paid in were 45 million by the time that deal was struck. So you can just see the scale of the sort of fees we're talking about. In the post office case, you remember, those of you who watched a year or two ago the fabulous programme with Toby Jones on, playing Alan Bates, the post office master, in that case involving hundreds and hundreds of postmasters and mistresses who had been found responsible for a post office system that actually was not worth its weight. And in that case, they managed to do a deal for £57 million with the post office, in terms of, I think, a few hundred of the post office masters and mistresses. And the funder took something like all but £11 million of that money. It was, it's, I mean, to be fair, Alan Bates actually subsequently said, because there was obviously a lot of criticism of the system, turned round and said, look, I know you're all being critical, but nobody would have actually helped us bring this case if it had not been for that funder. So even though it looks on the face of it disproportionate that the funder has taken away a significant proportion of all the money, that without their help we would never have been able to get justice. And it was really nice to see Mr. Bates just the other day getting a decent individual settlement on his case with the post office. So
30 seconds, Martyn.
So to conclude, the system has done ambles along in Britain, as I say, at a relatively low rate. The opt-out system has changed the system quite dramatically in terms of cases coming within the CAT. But in terms of the High Courts, it still ambles along at around this 5 a year. So even though I think it's the funding in this system is improving the access to justice, there is still quite a long way to go before we ever hit that 1,000 per year in the States. Thank you.
Super, Fredrik.
Thank you.
Okay.
Yeah.
Good evening, everyone. As you may have noticed, I seem like an old man when I was standing up from the table. That's because I am an old man, but also because I woke up this morning with almost acute lower back pain, so I have some difficulties moving. And the biggest problem is actually sitting down, so this is good for me to be up here. Thank you very much for the kind invitation to come here this afternoon. It was actually a lucky coincidence that I happened to be in London today. I just came from the London School of Economics, where I've been speaking at a conference, when this invitation came my way, and I thought immediately, I am not qualified at all to appear in the inner temple to speak about these issues. But then I noticed that my old and late friend Roger Scruton was one of the founders of this series, and I thought, well, if they can accept a troublemaker like him, perhaps they can accept a Swedish economist to come here and share his ideas as well. I'm very glad, because Martyn has done a very important task, which I had set out to do, which is just to explain what's been going on in recent years. And this is what I've been doing in a particular paper concerning collective litigation in the UK, which is that there has been a remarkable rise in cases over the last 8 years. And depending on how you cut the figures, we're talking about if you compare the last 4 years with the previous 4 years, it's an increase in 400% in the number of cases that have been filed. Almost 50% of all cases now are exactly competition cases, and they appear before CAT. The other cases which has the highest growth rates will be securities cases and GDPR cases. And I know Martyn's firm has also been involved in GDPR cases, but for securities cases, it's largely the same litigation funding cycle behind these type of cases as it is with many of the competition cases that Martyn referred to. The opt-out system is one of the biggest sort of explanatory factors if you want to understand why I've seen this growth, especially if you compare the UK with the rest of Europe, where opt-out systems are not in use. The other factor being the availability of funding. So when you're trying to understand differences between countries in what explains the rise of collective litigations, you're going to find that availability of funding from third-party litigation funders is a very strong factor. Many of these cases are basically imports from America. So when we was trying to build a full database on all cases of collective litigation in the UK for the past 10 years, we found that 40% of these cases were basically copycat cases from America. You may have seen law firm CMS comes out with an annual report on collective litigation in the UK, and I think the last one, which came out just a couple of months ago, pointed to, I think it was in total now 655 million class members in the UK as by the end of 2024. And the total aggregate sum in these claims added up to around, I think it was 135 billion pounds. I want to share 2 points with you on the system, and I really don't have much more qualification than to speak to you as an economist. I cut my teeth in competition and litigation funding for a consultancy called National Economic Research Associates in United States a long while ago. And the first case I worked on, the plaintiff was represented by one RFK Jr., which of course now is more famous for having a very notable position in the US government. But one thing which strikes me now when you compare what we found back then and when you did economic analysis of these cases or the consequence of them back when compared with today is, of course, that liability insurance costs has skyrocketed. And when you look at what different firms in different sectors need to pay in liability insurances, we're talking about a significant increase in cost and liability insurance over this period. So this is one of the obvious economic aggregates you can look at if you want to understand some of the economic consequences. One thing I've been trying to draw attention to is that this is complicating situation for many firms, especially for smaller firms and for research-intensive firms. So if you are a biotech firm, I know 2 cases in Cambridge, for instance, where they have been pretty advanced in moving from being pretty small, having patents, having pretty good intellectual property protection for what they're doing, to start the process to go towards marketing of it. But they weren't capable of doing it because they couldn't get proper liability insurance from insurance companies. And they had basically to sell to larger companies which have more power and more financial power in order to negotiate with insurance companies in order to get that. You will find that a lot of capital market investors are really, really careful about investing in small startups, especially in sectors like biotech and other sectors where litigation is frequent because they are at such great risks of being exposed, not necessarily now, but a few years down the line. We find that the claim sizes also have impacted quite significantly companies in the sense that how much money they need to hold on to in the balance sheets in order when basically a claim is being made against them. 25, 30 years ago, if you ended up with a claim in, say, 50, 75 million US dollars, that was, perfectly fine for them to do, also to negotiate with insurance companies about it. But when you are now confronted with a multi-billion dollar, multi-billion pound claim against you, there's no way you can deal with it financially than to put a lot of capital away in order to basically follow the different rules that applies also for public companies when they are targeted with these sort of claims. There are lots of other different consequences that happens as well, but my point is basically, which sort of brings me to my concern, which is that I think when you are having a system which is moving so fast in this particular direction, you are most likely going to have an economic impact from these type of cases, which affects the capacity in the economy to innovate, and especially for small companies to innovate. Lastly, given that UK has now become such an outlier in Europe when it comes to collective litigation, what can be done? The Civil Justice Council reported just before the summer in what I thought was a very good proposal. They are not proposing a direct regulation. They are proposing a couple of disciplines on this system in order to avoid that different undesirable consequences are going to arise. There has been talk about having a profit regulation, type of profit regulation that you can find in some other type of industries which have unique characteristics when it comes to attracting money from external investors. But they're not proposing that, and I think that's divisible as well. What I would add, and what I think is also increasingly important now when you look at what type of money that is coming in with litigation funders in the UK right now, is in the first place to be much more clearer that not just the court but also others need to be clear about who's the ultimate beneficiary of the investor in the investment company and potential returns that they are going to receive. The Civil Justice Council are proposing different type of transparency rules when it comes to location and who the investors are. But I'm saying this because developments that we see predominantly in America, but not just in America, is that you have litigation funders who gets money from competitors to companies that start to sue other companies in order to achieve competitive gains, sometimes in order to get them to release information about what's been going on. And there was such a case pretty recently which affected a British company, even a British-Swedish company, if I may add my own nationality to it, a company called AstraZeneca, which had to settle in America on about $50 million because of claims that were made by pharmaceutical buyers, but behind that was also companies that were actually competing with AstraZeneca. They are proposing that anti-money laundering rules should be applied. Of course, that is directly connected to a British company who was found to be in violation of the law and also had to pay out to a class. But when the bill was supposed to be paid, they weren't really sure about if they could do it because it was unclear who the company was, because they were located in a place where anti-money laundering rules were difficult to apply.
30 seconds, Fredrik.
Yes. So I think the Civil Justice Council has already proposed a development which I think is going to help to discipline the undesirable parts of the system while keeping opportunities for funding to come into cases which aren't of the kind that I've mentioned so far. I think they also are right in pointing to alternative dispute resolution mechanisms, and that there are lots of things that can be done on that part in order to avoid that we have to go to litigation, which is going to be very costly for everyone. And I can say this is a system which I favor quite, I do favor it. And partly because my own experience of it coming from a country like Sweden, where we have a very strong system for alternative dispute resolution mechanisms, which at the end tend to lead to better payouts to consumers and others that argue that they have been wronged, to a much, much, much lower cost than what you find when you have to go to court and litigate over these issues. So I thank you for your time, and I'll stop there.
Super. Fredrik, do you want to stay there for the question and answer? Fabulous. And as everybody settles in, let me add my 3 bits of context to this discussion before we get into the questions and answers. The first is one that Fredrik just touched on, which is on the 2nd of June of this year, we had the UK Civil Justice Council publish its long-awaited report on the regulation and future of litigation funding. And the report makes 58 recommendations, super interesting. As Fredrik said, a light touch statutory regime of regulation suggested to replace the current self-regulatory approach, not looking for a cap on funding returns, but looking for a court maybe to approve that the returns are fair, just and reasonable, and early disclosure by the funded litigants of the existence of the funding, the funder's identity, and the ultimate source of the funds. That's an interesting one, can be quite controversial. So that was June of this year. Then in July of this year, we had the Office for Budget Responsibility, who warned that the UK's national debt is on course to hit 270% of GDP by 2070, up 100% from today, and that climate-related risks are the major driver of that. The OBR found that the UK's public finances are in a relatively vulnerable position, exacerbated by climate-related risks. They looked at various modelling to suggest the damage to UK GDP from climate change, and they found that it was more severe than previously thought. The analysis looked at 2 different scenarios, a 2-degree scenario where we do better than we're doing at the moment. We managed to bend the curve of emissions downwards, so it's just a 2-degree warming. And in that scenario, GDP is estimated to be 3.3% lower each year in the 2060s than with no climate change. But the difference could be as high as 6%. And with a 3-degree of warming scenario, which we're headed for about 2.7, 2.6, 2.7 at the moment, it's at least 7.8% lower. So climate-related risks have a very serious potential economic impact. And indeed, for many large companies, for many small companies, climate-related risks are amongst the greatest of their risks in their economic and financial risk registers. The final bit of context is very recent, 14th of November, so just last week, where the High Court ruled in the case which is probably the biggest of Brazil's environmental disasters, being litigated in the UK in relation to the BHP group. And the High Court found in its first stage judgment that BHP is liable under Brazilian environmental law for the collapse of the Fundão Dam. It's also known as the Mariana case. That collapse occurred in 2015 as the result and resulted in the release of about 40 million cubic meters of tailings from an iron ore or from iron ore mining. A village was destroyed, 19 people were killed, the tailings polluted the river system along its entire course to the sea. In short, the court held that BHP was liable both on a strict and fault-based set of grounds, and although it wasn't the direct legal owner of the dam, they were directly or indirectly responsible for the polluting activity. A case and a piece of litigation not capable of being brought without litigation funding. So with all of that interesting context, but what we've heard from both our speakers in terms of the potential downsides of litigation funding, we turn to our discussion. And I might start with you, Martyn, because you mentioned both the MasterCard and the Post Office cases. And do you think that those cases and the others that are covered in the CJC report suggest that funders need to be regulated?
I think it's a very good question, and I think ideally no, but increasingly that feeling is starting to turn. The main thing about funding is that you've got two willing participants and you're trying to reach a deal. And as I said about the Alan Bates Post Office case, that in the end, even though they took away over 40 million of the 57 million pounds, the deal was a decent deal because the risks were so high. And if you're in a position where, let's say for the moment that the regulator says you can't get any more than 33% as the deal, which I think would be very likely, then I think just a lot of deals will never go through, and it means a lot of cases will not get funded because the risk is too much to the funder. So, I mean, it's for the lawyers to try and negotiate on behalf of our clients the best possible deal. And, I think largely we can do that. I mean, I say I am nervous about it because just what has happened with that and what happened with the MasterCard case just made me feel that the funders, I mean, they can be very avaricious. And I think, there are a side to me that feels, well, actually, having some element of regulation may be a good thing. So I'm slightly sitting on the fence, I'm afraid.
And Fredrik, we know that you're a fan of what the Civil Justice Council has suggested. Are there lessons from US states now limiting the freedom of third-party litigation funding that we should also be thinking about applying here in the UK?
I mean, I think there are a couple of things which are of interest when you look at what some of the states are doing. I mean, one of them is, of course, when you have states that are the third-party litigation funder, basically a sovereign wealth fund or a state which is putting the money into the cases. And I know at least two sovereign wealth funds that have already been part of providing litigation funding in the UK. There is a third one which was pretty recently established as well. And I would be very, very cautious about that. So I think that's one thing. Another thing which is of interest is perhaps not one of the more recent developments in states like Texas or Louisiana, but this comes from Florida and a few years ago when it started to put stronger controls on the claim sizes that you could file. And Swiss Re came out with a study about a year ago looking into what happened to liability insurance costs as a result of that. Now, they've been dropping remarkably as a consequence of that. And when you start to compare liability insurances between US states right now, you see that there is a huge discrepancy, a huge differential between these costs depending on the extent to which they apply rules on claim sizes and how you motivate them. And in the second place, the degree to which you can have unlimited or unrestricted third-party funding coming in. So I think there are some lessons to be learned. Each country will have their own unique system for regulation of these cases and these situations. So it may not be possible to generalize or externalize from these countries. But the point when it comes to external states and states with sovereign wealth funds that may not be democratic states, that I would be cautious about for the UK.
Yes, it's a very interesting question, the extent to which the identity of the funder or the cause that sits behind the funder is something that we should be concerned about or that we should be interacting with when we're thinking about litigation funding. One of the examples that's often, I think, thrown at, if I can use that phrase, those who think about litigation in the rights-based sphere, for example, is the question of whether certain types of American funding, say from pro-life organisations, should be funding litigation here in the UK. And certainly my answer to that question is, well, if the claim is a sufficiently good claim to get off the ground, then I don't think we should be looking at or concerned about where the litigation funding is coming from, if it's coming from a certain dogma, if it's coming from a certain fund, or if it's coming from a certain entity. But are you concerned, Martyn, about what lies behind the funding in that way when you're dealing with funders?
That is a good question. I think the answer is yes, to some degree. We wouldn't accept funding. We were in talks at one stage with a funder whose source of money was mainly from the Middle East and the oil money, and we decided as a firm we wouldn't actually take the funding for that particular case and went elsewhere. So I think we would. I mean, I'm not saying to the nth degree, but I think we would. We wouldn't feel in our firm good about getting money out of sources that are not ethical.
10 minutes to go, everybody, for your own questions and online. I see that there aren't any questions popping up yet, so start those little grey cells working. Not yet. We've just got our 10 minutes to go, but I've got you.
Can I make one point about... Yeah. So you made reference to the Brazil dam case.
Yes.
I mean, what is massively interesting is that the firm that is running that case, a firm called Pogus Goodhead, have said publicly that they have got funding to the tune of 500 million. Now, that is just astronomical in terms of what we are used to in our world. I mean, it's becoming much more American than we'd ever seen before in terms of just the scale of it. So, as far as I've understood from the judgment that you made reference to, Estelle, the case is worth 36 billion. So it's just huge compared to what we are used to. And the idea of a law firm getting that sort of money to bring a case, it just takes it into a different world.
If you want to have a look at the judgment, it's available through the Cornerstone Climate website. Small plug. I'll move on. Fredrik, you've talked to us about the issues to do with insurance, and certainly in the climate and environment world, we had thought at one stage that the insurance regime, and indeed the reinsurance regime, was going to save us because certain types of activity would become uninsurable and so would stop. What tends to happen is it becomes uninsurable and it carries on. But it seems to me that what you're saying that in relation to insurance, actually, it becomes a drag, or it becomes very difficult. Do you want to tell us a little bit more about that?
I mean, I think the first thing is, a large company that is willing to pay very much in order to get liability insurance will always get that insurance. I don't think there's any question about that. I mean, there are, of course, going to be companies with activities that are highly exposed to risk when the insurer will start to add conditions to the liability insurance, and that may or may not sit nicely with what the company wants to do. I think my greatest hesitation or greatest worry here is not so much about who can or who cannot get proper liability insurance among the large companies. It's much more what happens in the value chain, what happens in the supply chain, and what do companies do? I mean, I said when I was up there that you have already now, of course, different capital market institutions that are extraordinarily careful of investing in smaller companies. And they may not be small in terms of how much value that can be generated from their intellectual property in the future, but they may be young and they may be sort of inexperienced when it comes to building up the legal structure and the legal system that you need to have around you in order to defend against any liability claim in the future. But what you also see is that more complex, sort of sectors with more complex value chains, where it's difficult to attribute different particular parts or different particular suppliers or different sort of owners are different intellectual property when it comes to sort of when these cases come up in courts, and that forces many companies to reduce the exposure that you have in your supply and value chain. So you pull a lot more closer to yourself, and you avoid using other companies, which of course leads to efficiency losses. And this may not be prevalent across the economy, but we know a couple of sectors where it is a problem and where it's become a greater problem because there are fewer and fewer companies that are capable of utilizing a complex and long supply chain when there are liability risks in what they're doing.
I mean, it's interesting. It seems that the two of you are looking at, from different perspectives, at a sort of difficult middle sector in the areas that you'll be thinking about. But one last question from me before we go to the audience and to online. Martyn, do you think that funding has been a real benefit to claimants?
Yes, I think, and it does worry me at times whether the funders, the funders kind of came from nowhere and suddenly started funding the cases, and I'm just worried at times that it will disappear just as fast as it kind of arrived, and that would leave a very big hole in the legal system in our country. So I think, very large, it's been a benefit. I think for the reason the CJSC said that there are some extremes that it would be useful to be able, or good to be able to curb. But I think by and large, they've been a very positive side to the British legal system.
So we've got one question in the room so far, and there's a few online, so I'll start here. There is a mic. Sorry. And remember, Sir Geoffrey's 30 seconds.
Yes, Martyn, as Sir Geoffrey hinted, with the demise of the Legal Services Commission and the Legal Aid Board, the 1999 Act reduced the amount of, effectively, firms from 11,000 to 4,000, it's probably 500 now. There is a gap that you are filling, and you are really the last resort. You're a name that is known throughout England. The post-war consensus of the welfare state, the NHS and the Legal Aid Board, the ladder's been kicked away from legal aid. So without litigation funders, the money's got to come from somewhere. And thank goodness there are firms like you. Do you really think high insurance premiums from large companies that do dreadful things is a reason to stop litigation funding and to stop you?
A neutral question there.
As I've said, I think, litigation funding has become quite a fundamental part of the system. So, I would hate to see that disappearing for whatever reason. So, I'm a real big supporter.
We've got a question online to you, Fredrik, where there was an expression of great enjoyment about your discussion about ADR in Sweden. And could you go into a little bit more detail about how this might be able to be applied in mass litigation and in particular in the UK system?
Yes, of course. So there is an official dispute resolution board in the country where any consumer, a group of consumer, can bring their complaints. And the decisions from the board is it's voluntary for the parties to follow, but it is highly respected, and in most cases they are followed. It's very efficient. You can go into the website and look at the time, the cost for cases that come up. When there are particular cases of larger nature, you have the General Consumer Ombudsman who takes on the case and sometimes also go to court on these cases. They tend to be also cost efficient, time efficient, and what is surprising is that when you look at how money each individual in a group gets, they get more than what is expected, for instance, to come from the case that Martyn referred to, which is the MasterCard case. And to a cost which is, I don't know, but it must be a fraction. We're talking about decimal points of what the total costs have been in a case like MasterCard. So it is a pretty efficient system. I think Sweden has in total 3 collective litigation cases in total over the last 25 years. And It's
That
not.
many?
Sorry.
That many?
It's not because there aren't companies who are, or because they're not consumers who believe that companies are doing them wrong, but it's an efficient system because you can sort of receive swift resolutions without having to spend a lot of money and taking a lot of time for it. Now, then there are going to be differences. I mean, Sweden is not United Kingdom. It's not as if you're going to have a lot of international disputes coming to a Swedish court. You do have that, tribunals where you deal with dispute resolutions in big investment cases. You have the Stockholm Chamber Court who do that, but that, of course, is a completely different nature than what we're talking about here. So the complexity of cases are different than many of the cases here. But if you look at what the Civil Justice Council recommend, they are pointing in this direction as well, that there are a lot of things the UK can do in order to make the system more efficient to basically provide justice to those who believe companies have done them wrong.
Yeah. Martyn, have you had any interaction with ADR for these sorts of cases?
Some. I mean, most. Again, what it kind of goes back to a point that Fredrik was making was that if you've got a case that is worth a few £1 million, then it is nearly always worth trying to get ADR and getting it sorted out. I think what with the big cases, then it becomes less so, that the defendants just think it's worth throwing the dice, that the costs, in the end, if the cost of the case to run a trial may be 10 million, say, well, if the case is only worth 25 million, it's definitely worth having the talk. If the case is worth 100 million or 500 million, then the defendants usually feel, I think, that this is worth stroking the dice and giving it a go.
Questions in the room before I go back to online?
I have to declare, is it on?
Yes.
I have to declare an interest because I'm from the Competition Appeal Tribunal. Just to explain for those of you who don't know, 46 million potential beneficiaries, original claim for I think 16 billion, settled for 200 million, partly because the funders and the lawyers wanted a share of that. Now, it doesn't take you very long to do some sums that if the funders and the lawyers take a big slice of the 200 million, there isn't very much to share between the 46 million potential beneficiaries. So we at the tribunal, I'll stop in a moment, do have to consider both at the permission stage and at the settlement stage what is going on with the funding.
Yes, I think that's your experience.
Absolutely, and what was a bit shocking is that the funder has been trying to intervene to actually get the whole deal set aside so that they can get more money. I mean, I think it's quite shocking, actually.
I'm going to take one online. There's one here. Ladies, I expect a question from one of you as well. So there's a question here about whether it's easier to obtain funding for a group litigation order or for a collective proceedings order, and are there risks that are different there? I like a geeky question.
We quite often do cases that could be potentially with a group litigation order, but actually we don't. I mean, there's certain things within a group litigation order that can be a benefit or can be a detriment. So, I don't think there's any magic to a GLO in my view. I mean, it has some points to help it, but not necessarily. So, I would say probably only about half the group claims we run actually do within the GLO system.
Okay, I'll come to you in a second. Just one other one for Fredrik. Have you looked in your analysis, or have you thought about the potential for, if there's an increase in this type of litigation, the effect on the efficiency of the court systems?
The answer to that question is no, but it was one of the questions that we wanted to go into, but it's just very, very difficult. I mean, it's a very intransparent area, and trying to get hold of information, even from courts, is very, very difficult. So the answer is no.
Do you mind if I just in our emissions case, which is a massive case involving 1.6 million people, this is all to do with defeat devices in cars, the Dieselgate affair, writ large across many, many different manufacturers. And when we had the first hearing of the case back about 2 or 3 years ago, the president of the King's Bench Division, Victoria Sharp, presided over the hearing and basically said, look, you are bogging our courts down. You've brought 14 group litigation orders, all to do with emissions. We need to manage this case in an unusual way. So every 2 weeks we meet with the judges.
Wow.
Unheard of. We've got access to the court in a way that's never, I've certainly never seen before. And it's been brilliant. We are moving that case through, in legal terms, lightning speed. And it has been really, really good to kind of see the court be flexible, adopt different tactics as to how you kind of get such a big case with so many different defendants, so many claimants through. I've been really, really impressed with the court system, that it's been so flexible and adaptable.
Question here.
The writing on the wall behind you asks, is the rise in mass litigation distorting our legal system? And I'd be interested in your views on that question. So far, what I think I'm hearing is that good claims succeed, bad claims fail, and claims that might succeed might settle. So far, that doesn't sound like much of a distortion to me.
Agreed.
There we go. Question in the middle. So we've got 5 minutes left, everybody.
Okay, so I was really excited to come to this class, and it was also scary to hear how much we owe. Since 2013, I've earned a certain amount of benefit since having my children, and it's over 10 years now, and it has not increased. So here, how much we owe over 10 years, earning the same amount in benefit, based on myself and my children.
And so what's your
Is there
question?
any prospect that we're ever going to move forward? It's billions and billions of debt, according to what you said. And the same amount for 10 years. Cost of living crisis. Is it going to ever change? Are we going to get better? Is my money going to increase as the cost of living increases?
Well, I think the OBR's point was that unless we bend the curve of emissions downwards, if we're facing really significant climate change impacts, then the answer to your question is no. We're going to have quite significant difficulties.
But if I can just add a point on that, we have been doing our damnedest to find a way to soothe the pants off the causes of some of this climate change in terms of the likes of Shell and BP and the rest. We will do our damnedest to kind of make them pay for what they're causing.
So I'll have one more question online and one more question in the room. And then I'm going to take the last question, which is a lovely one about the International Court of Justice advisory opinion. What do the speakers think is the future of group actions in the United Kingdom in relation to environmental protection claims? Fredrik?
I wish I had something intelligent to say about that, but I don't think I have. I mean, it's you can see that the number of cases are increasing, but they're not increasing very much over time. I would imagine as we're getting more information, we are getting better at understanding how different companies, perhaps, and not just companies, but also others, are contributing to emissions, that there will be more cases as a result from it. But I don't know.
I think we've got a good system in our country, and I think the Brazil Dam case that Estelle referred to earlier is a massively good example of that. Initially that case was really in difficult territory, trying to get jurisdictional allowance for the case to be brought here. And the fact that in the end our system allowed it, 600,000 people from Brazil bringing the case, I mean, that's huge. So for our system to work, for that group and for the judgment that came out that you've referred to, I think is brilliant. And Lady Justice May is here, and she gave a judgment this summer in one of our cases to do with Shell in Nigeria. And again, the fact that we were able to bring a case on behalf of thousands of people in Nigeria here in terms of the operation of Shell in a foreign jurisdiction to make sure they can get justice is, again, I think, a real credit to our system. That we have a country, whereas against the United States, where it's very difficult to bring international cases in the US for various reasons. In our country, we've largely been very open to the idea that if British companies do ill on an environmental front internationally, then our courts are open to provide justice.
Right, everyone, we've hit 7 p.m. There's one question left in the room.
Hi, sorry, very quickly. Are there any particular sectors of industry where innovation and efficiency are being particularly stymied as a result of rising liability insurance costs?
Life sciences is the biggest one.
That was super efficient, guys. That was, wow, can I just say. To finish up online, so there's a comment and then an interesting question. So the comment is, given the sheer scale of modern group actions, isn't the real distortion coming from the litigation? No. Or from the fact that Parliament hasn't modernised the procedural architecture to deal with the type of litigation that we're facing. So put differently, are mass claims a symptom of systematic failure rather than a cause? Interesting one to ponder. And I'll take the last question, which is about the ICJ judgment. So you may be aware that earlier this year, I think it was last month, the International Court of Justice gave its advisory opinion on states' obligations in relation to climate change, and a wide-ranging opinion in which it held there are a number of sources of obligation which could give rise to wrongful actions on the parts of states if they fail to address climate impact. And the question is, what impact will the ICJ judgment have on the types of class actions or claims that we're thinking about here in the UK? And I think the answer to that question is maybe not directly, but maybe indirectly, because a number of the things that the ICJ advisory opinion says about the nature in which wrongful acts can occur and the background science which has been established and has been recognised to be the proper science which we can have reference, and the way in which the overarching obligations were defined, I think might have a resonance for how claimants bring cases, but I'm not necessarily sure we're looking at lots of cases arising directly out of it. Any final questions or points from either of... Jeffrey, do you want the last question? No. There we go.
The thing I would like to say is that I think we've got a good system in this country. I think it is between Europe and America. I think it doesn't have the excesses of America, but it's much better than the European states. I think that it's a system that we need to encourage, to develop. The things like the CJC, good points to be made. I'm very happy to kind of see those developments made. So I think we have a good system by and large, and one I'd like to see remain.
Fredrik, final word.
I don't think I think I've said what I want to say, so please conclude.
Kudos to the non-lawyer in the room for that answer.
I'm the Lady Justice May that was just being referred to. And I want to close just by saying thank you to our panel. I think you'll all agree that it's been an absolute treat to hear a discussion between such an experienced practitioner as Martyn and such an informed academic as Fredrik, so ably moderated by Estelle. Thank you all very much for the discussion, and it's going to continue outside, as you've heard. They will each be at a table. You'll be able to ask them some questions, so please do so and get a drink while you get them a drink, and then get yourselves one as well. Thank you very much. And I can't let you all leave before thanking the person who masterminds all this lecture series. Sir Geoffrey has been responsible for a long series over many years of extremely informative and entertaining lecturers. I just hope he doesn't stop. Thank you, Geoffrey.